All right, we're going to get finance going. Thank you all for coming this morning. The first item on the agenda is Senate Bill 2606, referred from tourism, and recognize Senator Chazanal to explain it.
Okay, this is the Mississippi Native Spirit Law, which was doubly referred. The bill expands the production and sale of alcohol for micro distilleries, encourages local commerce by providing an incentive for farmers to become involved in the production of native spirits. Basically, this will allow us to legally let people make alcohol from various grains and sugars that are locally produced and tax it. So it has a benefit for the state of Mississippi. I will tell you this bill is not for anything in my district. It's for a different part of the state. And I think there's another bill that's coming through that Senator Boyd has from up in North Mississippi. And it's an opportunity for us to regulate and tax something that's already going on. Any questions, sir?
Any questions by the committee? If not, do we have a motion? Motion's
Yep.
title sufficient. Oh, you have a question? Motion's title sufficient. Do pass. All in favor?
Aye.
Any opposed? All right. Thank you. Motion passes. Next one is Senate Bill 2764, and recognize Senator Blackwell to explain.
Thank you, Mr. Chairman. 2764 comes to us at the request of the Department of Health. They need this provision in order to comply with Initiative 65. And basically what it does is it gives the Department of Health the authority to delegate powers, duties, and other authorities to other state agencies that had agreed to accept that delegation and to pay these agencies for their services related to the medical marijuana program. The bill also defines the duties that the department will delegate to the Mississippi Department of Revenue for the collection of taxes on medical marijuana sales. That's an explanation of the bill.
Are there any questions by the committee? Senator McDaniel?
Thank you, Mr. Chairman. It's obviously going pretty quickly, so I don't know how detailed my questions will be, but I'll start with, I guess, the most pressing one. Senator Blackwell, this is going to impose a tax, correct?
It may impose a tax. As I understand 65, it does not specify a tax, but that if a tax is applied, then the Department of Revenue would be involved in the collection of those taxes.
If 65 doesn't call for a tax, and that's part of the Constitution, or if it remains there, you don't foresee some sort of legal conflict here between the attempted implementation of this tax as opposed to the constitutional issue that doesn't call for a tax?
To be honest, I didn't hear your question in entirety.
I guess I'm sorry, Senator. It's probably just my microphone. It's so the constitutional amendment does not call for a tax on the sale of medical marijuana. That's correct.
To my knowledge, that is correct. But it allows for one.
It does allow for one. Okay, and so what this would do, basically, fill in the blanks, essentially, and allow for a tax on the sale of medical marijuana. I guess my concern is I'm trying to understand the purpose behind the medical marijuana initiative is to treat it like a pharmaceutical prescription, right?
I don't know
A medicine.
what's behind 65.
Okay.
I personally disagree with putting it in the Constitution. But
Right, I think a lot of us had some concerns about that for sure. My concern now, though, is I can't think of another prescription medication that we tax. Can someone answer that question here? I mean, do we maybe defer to legal counsel? In Mississippi, do we tax prescription medications in this state? good for the belly, right? Yeah. I think there's a sales tax exemption across the board on all prescriptions in this state. Well, I haven't read that in some time, but it's back in my mind somewhere. Yeah. Apparently that caused some confusion. Yeah.
So, I apologize. This language is the language required from Initiative 65, so language that's in the Constitution.
Right, but 65 doesn't call for a tax, does it?
It does.
It mandates a tax? 65?
I believe it requires a sales tax of 7%, if I'm not mistaken. I'll go back and look.
Yeah, we need to. That's
Mr.
something
Chairman,
I'd like to get an answer.
I believe 65 allows for a tax, but it does not specify a tax.
And what was the funding mechanism for 65?
I believe it may be the application fees.
Just the application
I'm not
fees.
sure where all their funding is coming from. But it did allow for a tax, but did not specify a tax.
And I apologize. I'll pull that up. It was my understanding, though, that it was dependent on a 7% sales tax.
Okay. Yeah, I don't recall the language of the initiative. I'd like to get an answer to that at some point, for sure, because under these circumstances, assuming the premise behind the initiative is sound and this is for medicinal purposes, people that are going to be suffering are going to be taxed on a medication, and I'm not sure we tax other medications in this state. This would be an anomaly in my mind. I'm trying to see, is that the answer? Do we tax other medications in this state? Do we know the answer to that question?
Technically, though, it is not a prescription medication. It can't be prescribed. There is no take this amount of this product this many times a day or every so many hours for, that's approved by the FDA to be considered a prescription product. And I believe it was passed as a fee, not a tax, but it equals the sales tax of the state.
Yeah, a tax or a fee, the one is still money out of a consumer's pocket, right? So the end result is the same. Private revenue is taken from the consumer. And my impression was the whole point of the initiative was to allow folks to receive medical marijuana by prescription. Is there another way they can receive it but for prescription?
It was not by prescription. You get a card, essentially a certification card from a physician, but it's not a prescription.
Can I acquire it without the card?
No,
Who gives me the card?
a physician.
So a physician gives me a card, but not
a prescription comes with also, when you get a prescription, it's not just for a medication. It prescribes a certain amount of, it says, take one of these every 4 hours for pain, say,
Right.
Or take this twice daily with food. The card does not have a prescribed method of taking
Right,
it.
so the individual will have a card which gives them permission or her permission to seek medical marijuana if they're so inclined.
That's correct, and possess it.
And they would go
and
to a
use it.
dispensary and take it and possess it. But still, I guess to my original point, whether it's a fee or it's a tax, we are effectively imposing some levy.
I believe
Again-
70-something% of Mississippians impose this levy on themselves.
Yeah, I was not aware that's what I'm saying, though. Maybe I don't know the language. It was my impression it did not mandate a tax. That was my impression.
I think, though, if it does not, then the program won't make it, because we cannot fund the program, as I understand it, through legislation. It's completely closed off for revenue and appropriation. All money stays there. So if we don't have this fee, I don't believe the program is going to survive. From what I've heard, the language in 65 may not be sufficient to even start the program.
Okay. All right, thank you, Mr. Chairman.
Senator Blunt?
Thanks, Senator Johnson. Senator McDaniel, I had the same question you did. I think it's a good question. So I went and pulled the initiative right before we started this morning. And Section 6 says, this is Section 6 of Initiative 65, which is in the Constitution. In addition to the fees applied to issuing identification cards and licensing medical marijuana treatment centers, the department may assess up to the equivalent of the state sales tax rate to the final sale of medical marijuana. So I think, my understanding, Senator Blackwell, is that this bill, not the next bill, but this bill is what the department is requesting so that they can assess the equivalent of the state sales tax rate, which is specifically allowed in the Constitution. Is that right?
To my knowledge, yes, and it allows them to make those transfers in between the other agencies that they need to work with.
And it's just the state sales tax rate. It's not any, it's not any extra tax. It would not be allowed by the amendment.
That's correct.
Okay, thank you.
Any other questions? Do we have a motion? Actually, was there an amendment that you had for this one? Okay. Do we have a, thank you, motion is title sufficient to pass. All those in favor? Aye. Any opposed? No. Ayes have it. Next bill is Senate Bill 2765, and recognize Senator Blackwell to present it.
Thank you, Mr. Chairman. Senate Bill 2765 is you have before you a committee sub. We've been working for a while on this. It still needs some additional work. There is a reverse repealer in this bill. But this bill would basically establish the Mississippi Medical Cannabis Act. Section 2 there includes a lot of our definitions. Section 3 is protections for medical use of cannabis for card holders, non-resident card holders, practitioners, medical cannabis establishments. Section 4 has some of the limitations, which include, unauthorized use, undertaking any task under the influence of cannabis, possession of cannabis for medical use in a correctional facility unless the facility is elected to allow the card holder to use cannabis, smoking cannabis in public space. Section 5 has the discrimination prohibited for using medical cannabis, basically saying a school or landlord cannot refuse to enroll or lease to a person because they use medical cannabis. Section 6, addition for debilitating medical conditions. I believe this bill includes all the conditions that were in 65, as well as it allows for the department to expand on those. Facility restrictions in Section 8 allows facilities such as nursing homes, hospice, assisted living to adopt restrictions on the use of cannabis by the residents. Section 9, issuance and denial of registry identification cards. 60 days after the act passes, the department shall begin issuing ID cards to qualifying patients who submit various forms required, such as their medical records and indicating diagnosis for the debilitating medical condition. Section 12 is a verification system. The Department of Health shall maintain a confidential list of persons who have been issued registry ID cards. It sets forth what information is collected. All records kept in that system are confidential and exempt from the Mississippi Public Record Act. It also provides for a number for the law enforcement to call to verify that the card holder is a legitimate card holder. Section 15 gets into the licensing of medical cannabis establishments. The Department of Ag will be the one that issues the licenses for cultivation processing facilities and shall issue at least one dispensary license for each county that applies. There is no limit on the number of dispensaries. There is no limit on the number of cannabis establishments. There will be a 4% excise tax on the cultivation and processing facilities collected by the Department of Revenue, and there will be a 10% sales tax on at the dispensary collected by the Department of Revenue. Section 16 deals with local ordinances. Local government may enact ordinances or regulations not in conflict with this act, governing the time, place, and manner for medical cannabis establishment operations. Section 17 various requirements, prohibitions, and penalties. It requires that a medical cannabis establishment shall conduct a background check on their members. Requires that a medical cannabis establishment may not employ any person who has a convicted disqualifying felony offense or embezzlement or is under the age of 21, and requires that medical cannabis establishment shall implement security measures. Section 18 has the agencies to issue regulations. The Department of Health, Department of Ag, and Department of Revenue shall issue rules and regulations based on guidelines and criteria in this section to operate the Act. There's violations for the Act. There are various penalties. That's in Section 19. Section 21 deals with confidentiality. It set forth the data that is confidential and exempt from public records. Section 23 talks about annual reports, requires annual reports to the legislature on the number of applications or registry ID cards received, number of qualifying patients and caregivers, number of registry ID cards revoked. Section 25, again, establishes the sales tax for medical cannabis to be 10%. Section 27 deals with the where that revenue goes. 25% will go to the early learning collaboratives. The next 25% will go to the standardized dual enrollment program for juniors and seniors, and the remaining 50% will go to last dollar scholarships for junior college and college students. Participating students may not receive more than $6,000 per year in scholarship funds, and that sort of parallels with what the Pell Grant does. And the remaining sections deal with basically exempts medical use of cannabis as unlawful under the Mississippi Medical Cannabis Act. It basically exempts caregivers, practitioners, et cetera. It's an explanation of the bill, and Mr. Chairman, I do have, there's a Scribner's error on line 1238. The third word in says prescription. That should be certification. So if could do an amendment to correct that, appreciate that. Again, this is a bill in progress. We'll see some additions and some tightening up over the next 9 days, but the primary objective at this time is to get it out of committee so that we can continue to work on it. I'll yield for questions.
Before we take any questions, I'd like to get a motion to make that amendment, and then we'll take up the bill. Motions to adopt the amendment. All in favor?
Aye.
Any opposed? All right, the amendment is adopted. Any questions on the bill? Senator McDaniel?
Thank you, Mr. Chairman. Senator Blackwell. There's an awful lot of things in this bill. And I guess my first concerns deal with if I want to be in the medical marijuana industry or business as a cultivator or a dispensary, what requirements are imposed by this bill on me, financially speaking?
I don't have that right in front of me, but there are some financial, the company will have to have certain assets, certain experience in dealing with large cash amounts in terms of revenues. And again, we're basically tweaking those numbers as we go along.
All right, that makes sense to me. I don't know what those numbers are, but you would agree with me that the higher those numbers are, the less likely small businesses in our state can compete in this endeavor, correct?
To some degree, but we've lowered the threshold. This bill basically started out as a draft from the Arkansas bill that passed. And so as we've gone through it, initially there was some limitation on the number of cultivators. But when I further researched what was going on in Arkansas, some of the concerns was that they had a limitation, but then they couldn't get the product to the dispensaries. So we've removed that. So it's basically, there's no limitation. At the same time, we don't want to be like Oklahoma, which has over 6,000 growers. I don't know how they manage to regulate. It's basically recreational marijuana, and that's how I perceive 65 to be with some of its lack of regulations and an open door. Hey, I'm going to grow pot. I got 2 acres. I'm going to grow some pot on it, and I'm going to put a cargo container out front, and that's going to be my dispensary. Now, this is supposed to be medicinal for medicinal purposes. So under these regulations, there are guidelines. It's going to be grown indoors. It's basically going to be hydroponics. There's going to be quality checks. There's going to be tagging from seed to sale of the product. So this is a true medical cannabis act.
Sure, and that makes sense. Your example of the dispensary and a cargo container, that could be handled in a different part of the statute. I guess my concern is the anti-competitive nature of the amount of business a business owner must have done to even be eligible to engage in this endeavor. If we put those numbers too high, we're not going to find any Mississippi businesses that can compete.
Yeah, I don't think the numbers are too high. I think we've been real reasonable in bringing those down. And again, Senator, this is a work in progress.
Yes, sir.
And certainly I'd welcome, you've got some comments on where that threshold would be happy to entertain that.
Yes, sir, thank you for that. I tell you where I would like for it to be. I'd like for it to be fair. I'd like for it to be a chance for every business in Mississippi that's so inclined, that has the manpower and can compete in the marketplace to have a chance. What I don't want to do is to increase it too high, thereby precluding Mississippi companies from having a fighting chance and essentially mandating, by inference, that these companies from out of state come in and take over this business. That's what I'm trying to avoid.
Yeah, well, 60% of the ownership has to be Mississippians.
Okay, let's talk about that for a second, because that's a good criteria. But if I'm an out-of-state company and I'm so inclined, nothing would prevent me from coming into the state, creating an LLC, hiring the requisite number of individuals pursuant to this act, and still be able to compete. But the anti-competitive nature of the high amounts of the previous business would give me an unfair advantage. So I'm still able to come in, create an LLC, and compete, correct?
Yes.
Okay.
But you're going to have board ownership is going to have to be 60% Mississippians.
Right, but see, that's the thing, though. If you're an out-of-state company, that's not terribly difficult to do because, well, naturally, the amount of money that stands to be made is going to be very attractive to anyone.
Yeah. Well, as long as you're giving this example, if you wanted to open up a Chick-fil-A, you want to be an entrepreneur, you're going to have certain assets. Are you not?
You are. I've seen some of that.
So, but for just about any franchise opportunity, you're going to have, the requirement is going to be that you have certain physical assets. In many cases, they're going to want to know you've run a business in the past. Right. So what we're doing is nothing out of line. And actually, we have lowered the threshold from a dollar amount to, I think, a reasonable amount.
Yeah, I think that the purpose of the franchisee arrangement there is to make sure the franchisee doesn't default and thus put the franchisor in a bad light. Right. But most
and exactly
right.
the same with us. We
in
want to make sure
that's right.
Want to make sure it's a going concern.
I agree with you, but bear in mind there is an anti-competitive nature there. The higher that number is, the more difficult it is. And so, with the franchise agreements, they do have lower numbers, I think, because we don't know what the number is here yet. I don't. I'm speculating it's going to be pretty high. And it may not be high, and if it's not, then I guess my concerns are not well-founded. Maybe that's the next question. How high is the threshold? Do we have an answer to that?
Just hang on. I'll try to find that section for you.
Would you repeat how high the threshold is?
Right. I'm just trying to figure out if I want to compete in this endeavor, what assets must I have
What
before I'm
capital
allowed?
requirements there are?
Well, either assets or I think there was a term, past business experience or past business sales.
Well, that's in reference to the franchise, but in Section 15, we talk about the cultivation processing facility license application fee shall be non-refundable, $100,000. And then the initial dispensary fee shall be non-refundable, $20,000. Renewals for the cultivation are $100,000, and renewals for dispensaries, $10,000.
And those are just the fees,
Those are the fees, application fees, right?
right?
Licensing fees.
But what number is it, what I have to acquire in assets to get a permit here? Is that,
The capital requirements.
right, right?
Applicants for a cultivation processing facility license shall provide proof of assets or a surety bond in the amount and proof of an amount in liquid assets as determined by the Department of Ag. And applicants for dispensary license shall provide proof of assets or surety bond in the amount of $250,000 and proof of an amount in liquid assets as determined by the department.
To answer your question, it sounds like the capital requirements to get started are to be able to secure a security bond, fund the application fees, and fund the necessary capital expenditures that you would need to get started.
Right. That makes sense. I'm just, again, this bill is extensive, and what I don't want is to have numbers, you know, 10, 12, $50 million for a person and assets before they can enter this business, because that's going to preclude just about every Mississippi company from competing in this endeavor. And that's just what I'm trying to avoid here, and I just don't know what that number is.
Yes? So
So
I'm
we
not
can
sure
move
what
on.
the cost of a $250,000 surety bond is,
Okay.
or what the requirements are to secure that. That would have capital requirements in and of itself, I believe.
It would.
Outside of that, the fees of $100,000 plus $120,000 to $220,000 for application fees to get started. And then once you get past there, it just depends on what size operation you have and the quality that you set it up to.
Okay. Senator Blackwell, what I'll do for purposes of time, I'll come see you about those issues at some point, and perhaps we can handle that on the floor.
Yeah, and I appreciate that. As I said before, this is a continuing work in progress, and
Yes,
we
sir.
did put a reverse repealer in it. I'm sure the House will have its concerns as well, so
All right.
hopefully we can get it right.
Thank you for that. Just one more question then, and I'm going to move on. I have an AET meeting upstairs, I think. It's about to take place. So, what's the provision for minority set-asides in this bill?
There is some provisions that does allow minority, or actually require minority participation. And there's we have other minority groups shall mean an individual who is Hispanic American, American Indian, Asian American, Pacific Island America, a woman, or if a service-connected veteran with a service-connected disability is designated by the United States Department of Veteran Affairs, in addition to African Americans. So those are the minority members identified.
Would you have any objection if we added the Irish to that list?
Not at all.
All right. All right. Here's my other question on that, and the French as well. Is it mandated? Is it required? In other words, it's one thing to have preferences or set-asides. It's quite another to mandate.
It's a requirement to have an owner that is a minority member.
So a Mississippi business that does not have a minority member may not compete in this enterprise.
They're going to have to adhere to the guidelines in the bill.
That sounds potentially legally problematic. You know, the state is allocating resources here, and it's doing so in that regard based on an immutable trait, if you will, race or gender, whatever the case may be.
I'm sorry, I don't see where's the state allocating resources?
Well, this is a state bill, and it's my understanding the state will not allow someone to compete in this industry unless it has a minority-owned business. That's what I'm hearing. If that's the case, the state is allocating resources, and it's doing so based on a racial preference. If that's the case, then I don't understand how it withstands equal protection scrutiny if it's challenged in court. If it's a set-aside, that's one thing. If it's a preference, that's one thing. If it's a mandate, that's quite another, because you're telling a whole bunch of Mississippi businesses they cannot compete here unless they go out and find a minority partner. I don't know how legally that's justifiable.
Well, I'm not an attorney, but since I've been here, I know we've passed a number of bills that require minority participation.
As a percentage, usually as a percentage.
I
Okay.
can't argue with you on, but I know we have done it, so.
If you don't mind, could I get with you on that issue as well at some point, maybe talk it out?
Yes, sir.
Okay, thank you, sir. That's all the questions I've got. Thank you.
Thank you, Senator McDaniel. Senator Horn?
Thank you, Mr. Chairman, and I'll try to be brief, but I'd like Senator McDaniel. I have a lot of questions about this bill. This is my first time looking at it, so first let me ask, who pays the excise tax?
Well, the excise tax is going to be at the cultivation, so the cultivator will pay the excise tax.
The grower will pay the 4%?
Yes, sir.
Okay. And why is the sales tax set at 10% versus consistent with the state sales tax?
Because that's just the figure that we set aside for medical cannabis taxation.
Okay. And I'm looking at disqualifying felony offense, and I'm looking at the ways that you can have a disqualifying felony offense. To some extent, to Senator McDaniel's question, the war on drugs has had a devastating impact on the black community. You mentioned that there are provisions for minority participation in this bill. What line were you looking at when you were speaking about that?
What line was I looking
Yes.
at? I'll have to get back to you, Senator, with that, but it is in the bill.
I believe maybe 867 is what you're looking for.
Okay. Thank you. And can you tell me if there's anything in this bill that countermands Initiative 65?
That countermands 65? No, sir.
There's nothing in it that
65 is its own thing.
Right.
This bill is its own thing.
But there's nothing in this bill that supersedes Initiative 65.
That supersedes it? No, sir.
Is there any role offered to the University of Mississippi's marijuana research facility that's in this bill?
Not yet, but that is, as I mentioned several times, this is a work in progress. We've had those discussions, and I'm probably looking at adding that language to allow for them to be involved as a testing facility.
I understand that they're the premier facility for research and testing of marijuana in the country, so we got them right here. Why don't we use them?
Absolutely.
So can the health department, if we pass this bill, can the health department continue to promulgate rules and regulations on top of what may be in this bill?
There will be, not so much the health department, but the Department of Ag would be responsible.
Mm-hmm. Okay. Thank you, Mr. Chairman. Thank you, Senator Blackwell.
Thanks, Senator Horn. Senator Sojourner?
Thank you, Mr. Chairman. Senator Blackwell, I think I must have had maybe looked at a previous version of this bill as compared to the committee sub, but I think there was language in it where you had to have like 20 million in surety bonds and 10 million in experience. Is that language still in this bill?
No, that language has been removed. As I've said, this has been a work in progress. It started out as actually, I did this actually in 2018, but and it was based upon the Arkansas law. So as we've gone through and have learned more, we've got more input. We've hopefully are refining this so that we can have more participation and not be as punitive as what the original draft seemed to be.
Thank you. One other question. Are there other agriculture-based products that require cultivation and processing upon which we collect the 4% cultivation tax?
I don't know that.
Do we know that? I'm not aware of any, but I'm sure there's a lot of things I'm not aware of. Okay, thank you. I too would like to just visit with you some as this moves forward.
I'm sorry?
I too would just like to visit with you on a couple of things as this moves forward.
Be happy to.
Thank you.
Any other questions? Senator Barrett? Senator Barrett?
Yes, sir. Thank you, Mr. Chair. Senator Blackwell, so I understand, will 65 and this proposed bill coexist?
They could. If 65 is struck down, then we have another vehicle for medical cannabis, and obviously over, I think it was like 73% of the people voted for it.
Right.
I don't think they all knew what they were voting for under 65, other than they say, hey, we're going to have free medical marijuana. So.
Well, excuse me. I ask because in my district, it was 65 overwhelmingly passed. And if 65 is enacted and is not struck down, that would supplant this bill?
No, sir.
They would coexist?
They'd coexist.
Okay. Thank you.
Okay.
Senator Jordan?
Yes. Mr. Chairman, thank you, Mr. Chairman, and Arthur, tell me, since there are so many people wanted this bill, 65, what are some of the conditions that it is used for, health conditions? Can you point out some? I'm looking at line 3 where it talks about them. Can you name them? Because I don't want anybody getting this just saying they have a health condition and it's not there and some crooked.
Yes, sir. Beginning on line 96, it talks about debilitating medical condition.
96?
Yes, sir.
And those are the conditions. Let's see. Yes, sir. Oh, Parkinson, cancer. Okay, all right. I know Ole Miss have done studies of this for decades, marijuana, and there have been some analysis done that cannabis could be very, very harmful that this drug contains. So I just want to be absolutely sure that somebody who loves it, just not saying they have a medical condition from some quack medical person that will allow them to get it.
Well, they're still going to have a relationship with a practitioner, and that practitioner is going to have to diagnose them as having one of these conditions and to give them a certification to obtain the medical marijuana.
Okay. Just wanted the safe part, because in my district, more people turned out for this than ever voted. Turned out it was very high. Thank you very much. Thank you, Mr. Chairman.
Thank you. Any other questions by the committee?
One last.
Senator Blunt?
Thank you, Mr. Chairman. Senator Blackwell, I appreciate your work on this. I wish we had been having this conversation a couple of years ago, but right now, today, we have Initiative 65 in the Constitution. And just to backtrack, I mean, tell me if I've got the big picture right, is 65 is in the Constitution, and maybe the court will rule and maybe they won't, but I think we always have to operate as if what's in the Constitution today is the Constitution. I mean, I wish voter ID hadn't been adopted by the people in the Constitution, but it's in the Constitution, and there it is. So, assuming that the Constitution stays the way it is, or what we're doing is really just setting up two parallel tracks, two different regulatory schemes run by different agencies with different requirements, and a provider or a patient can avail themselves of either one, because there's nothing in this bill that can change what's in the Constitution. And as you know, it's very specific what's in the Constitution, what the money can be used for, what the requirements are, what the patient qualifications are, that the money cannot go to the general fund, and all that stuff. We can't do anything about that with the bill. So are we just setting up two parallel regulatory structures that a patient or somebody in the marijuana business can choose to do either one? And if we are, why would someone who's in the marijuana business want to fool with any of this stuff when they've got a constitutional provision that doesn't set these fees or anything else?
Well, that's what set things out in the business world, that you've got choices. As a business person, I think 65 is unconstitutional. And I say that because my business is not protected. Your real estate business is not protected. The farmers are not protected. But yet we've taken this one product and this one industry and we're protecting it in the Constitution. I think that's a violation of the Equal Protection Act.
Well, that horse has left the barn, Senator Blackwell.
I'm sorry?
That horse has left the barn. I appreciate your points, but I mean,
But
you know, that's
65 is also in front of the Supreme Court. So what happens if 65 is struck down, and we don't have something in place? We've already know that about 73% of the people want medical cannabis. So this bill would allow them to have that process, plus the tax revenue that if it's generated by 65, it goes to the industry. It doesn't go to the taxpayers.
No,
it doesn't benefit anybody but them.
Well, it goes to the health department to administer the program, and you know we could debate whether that's the way it should work, but
Sure.
But that's what. So my question is, if 65 remains in the Constitution, then what's going to be the impact of this legislation?
Well, under this, with the guidelines, people, if they're supposed to get 20 milligrams of THC in a product, they're going to get 20 milligrams. Under 65, hey, whatever's in the joint's in the joint. So if you got herbicides, insecticides, hey, have at it.
But 65 is the Constitution, and so I mean, I can choose as a patient or somebody in the marijuana business, I can say, well, here's a regulatory structure over here that's in the Constitution, I can choose that.
Right.
Or here's another one over here, I can choose that. But they're both going to exist and be parallel to each other. So
They may, and that's somebody's choice. It's my choice as a businessman if I want to get into become a cultivator or if I want to have a dispensary. It's also my choice as a patient where I go and get my certificate filled.
So if you're a businessman, you can say, well, I could pay this big licensing fee and have my product I sell taxed at a higher rate, or I could not.
Yeah, because I got a quality product, but we can go around in circles on this. But
All right. I wish we'd been having this discussion last year, but I appreciate it. Thank you, Mr.
18
Chairman.
would have been a good year to have done it. But
Thank you. Senator Fillingane?
Thank you, Mr. Chairman. Question about, and I support what you're doing, Senator Blackwell, with this. I'm just curious how we arrived at the 10% tax on the retail sale of the product.
it was just a figure that we derived. There was nothing behind it, other than we thought it should be higher than the traditional 7% sales tax.
Well, that's what I was curious, because we've heard questions about the constitutional amendment. I think it allows for the traditional 7% sales tax. So if you were going to leave it at 7%, I could understand that. But if you're going to go above the 7%, then why'd stop at 10? I did a quick search of what some of the other 9 states in the country who have passed marijuana in various forms or other for sale, and it appears the 10% would put us at the very bottom nearly of that list. You have as high, I've found in Washington, as 37%. Alaska, California, Colorado appear to be around the 15%. Massachusetts at 10.75%. Oklahoma at 17%. So, I mean, it's all over the board, but I guess my question is, if we're going to tax this stuff and we're going to not do it just at the 7%, then shouldn't we try to get as much money for the state as possible? And why would we limit just to 10%?
Thank you, Senator. We looked at those other states, and some are, I think one's 57%, possibly.
37 is what I found in Washington State.
Okay, I think there's one higher than that, but we thought 10% was reasonable. It's a increase over the, our current 7, and it's not going to break the bank.
Any idea of how much this would generate, the various fees and taxes in your bill?
The initial projections show in the first year somewhere around maybe 32 million, and then above that, we're talking about hundreds of millions.
And when you say beyond that, are you presuming that this is just a first step and that it will eventually become expanded to include just recreational marijuana, or you're talking about within the medical
No,
cannabis?
just within the medical cannabis arena.
Okay, thank you. Thanks, Mr. Chairman.
Thank you, Senator Horn.
Thank you, Mr. Chairman. Senator Blackwell, on line 140, a disqualifying felony offense would include a violation of a state or federal controlled substance law that was classified as a felony in the jurisdiction where the person was convicted. So if someone were convicted of possession with intent to distribute of a controlled substance, and they were convicted and they went to jail, or they accepted the conviction and were put on probation or parole or something, they would be disqualified from holding a license, the way I read this.
I believe you'd be correct.
Have you given any thought to putting a time limit, say if a person had that conviction, but it was 20 years ago, that they still would be eligible to participate?
I don't have a problem discussing that with you.
I'd like to do that. I'll follow up with
As
you.
I said, we've got, I think, 9 more days to, before we take this bill up on the floor, and I think that should give us enough time to try to get the best bill that we can. So, but I'll be happy to listen to you.
Thank you, Senator Blackwell. Thank you, Mr. Chairman.
Thank you. Any other questions? Motion is title sufficient, do pass committee sub. All those in favor?
I'm sorry, I just want to say just a couple of observations really quick, if that's okay. Speak on the bill. Just really quick, I appreciate what you've done. That's hard work. There's a lot of details in there. As we move forward, I want us to be clear about a couple of things. I think that there's 2 possible pitfalls here. The first, if we attempt to frustrate the intent of Initiative 65. The people have been very clear about their wishes on that issue. The second, if we attempt to frustrate the marketplace. And that's where I come down. I'm concerned that if we draft a bill that doesn't allow for competition for all Mississippians, that again, our people are left out. And I want to be sure as we move forward that we handle those provisions accordingly, because the more details and specifications and requirements we place in this bill, the more difficult it is for Mississippi businesses to compete. So just keep that in mind as we go forward. I appreciate what you're doing. I think ultimately you'll probably clean it up and it'll be a much better piece of work, but let's just please try not to frustrate the intent of the people or frustrate the marketplace that makes Mississippi so valuable. Thank you.
Thank you, Senator McDaniel. Again, on the motion of title sufficient, do pass committee sub. All those in favor, say aye. Aye. Any opposed? No. The ayes have it. Next on the agenda is Senate Bill 2877. This piece of legislation deals with the lottery fund money that we set up in August of 18 special session. It takes, in that, we set up the first $80 million that comes in goes to MDOT, and then we split it up after that. What this bill proposes is that for the next 3 years, we take that $80 million that is currently going to MDOT and direct MDOT to disperse it to counties and cities for road and bridge repair under the Emergency Road and Bridge Repair Fund. again, it's only for 3 years. It's for that $80 million. We're just directing MDOT to use it there. I think the intent is that in our counties and cities, we are struggling even with the additional use tax money we provided to stay up to date with road and bridge repair. I know in my own district, we have several wood piling bridges that are in need of repair. Some get shut down. People have to drive 20 and 30 miles out of the way to get around them while they're being repaired, and that's when the county has the money and can get it done. This would be a tremendous aid to helping our local governments get caught up on roads and bridges that they maintain. That's an explanation of the bill. Is there any questions? Senator Blackman?
Thank you, Mr. Chairman. The $80 million presently, what is it being used for?
So it's a state highway fund.
It goes to the state highway fund, but didn't we specify what that money was to be used for?
I believe so. Just one second, I'll answer that for you. Currently, it is set up to repair, renovate, and maintain highways and bridges of the state, and that's essentially what it does, just maintain.
Okay, so state highways.
Yes.
And now we're going to say that it's to be used for roads and bridges.
That are maintained by counties and cities for a period of 3 years, and then it reverts back to how it is currently.
Okay, thank you.
Any other questions? Senator McDaniel?
Our state highways as a whole have done pretty well. It's the problems we're having locally, counties and cities, right? That's where we're having problems.
Yes. Not that we want to neglect in any way.
That's right.
State highways.
That's right.
Right now, overall, state highways are being maintained well. We want to continue that. However, we have a dire need for help with counties and cities, roads and bridges that they maintain. And this is just a short-term diversion of money to help them get caught up.
Makes sense. It's going to the more needed areas
Yes.
quickly as opposed to otherwise, correct? Thank you. That's good.
Thank you.
Appreciate it. Thank you very much.
Question.
Thank you,
Senator
Mr. Chairman. Just real quick, I'd like to speak just for, real quickly on the bill. To Senator McDaniel's point, our state highways currently rank 8th in the nation in terms of the quality of our state-funded roads and bridges. As we all know, the true problem is our county and city bridges. The ERB fund, which was set up in 2018, has proven itself to be a very efficient and a cost-effective way to get roads and bridges funded. Primarily, that fund was focused on bridges. This bill would specifically direct that 50% of that money go to the county roads and bridges, and 50% would be focused on your municipal and city streets, roads, and bridges. So I just wanted to clarify that.
Thank you very much. Senator Horn?
Thank you, Mr. Chairman. I think I found the answer to one of my questions on line 34. The funds shall not be used to pay for pre-construction costs. So this is existing roads and bridges that are in need of repair. Is that correct?
Yes, that's correct.
All right. And is the administration going to be through MDOT or through the State Aid Road Program?
It's through MDOT, under the direction of the Emergency Road and Bridge
Repair Fund. Okay.
Yes.
Thank you. Appreciate it.
Senator McMahon?
Yes, Mr. Chairman, I have an amendment. I'm going to state the purpose of the amendment and then ask the best way to word this with council. My amendment would be that of these funds, no more than 25% of these funds could be spent in any one congressional district in a single fiscal year. That would be my amendment. So in other words, this fund cannot all be spent on one project in one location of the state. It has to be spread out over the 4 congressional districts. And no one district can receive more than 25% of the funding in a single year. That's my first amendment.
Before we vote,
Just a question on the amendment. I think the bill already calls for equal disbursement, doesn't it?
I want to be sure, I want to clarify that. If you see it
I'd love for you to
I think
point that out, Senator McDaniel.
I think it does. Let me find it here. Got a lot of paper here.
So the language that it has, the specific breakdown is only that 50% goes to counties for use for their roads and bridges, 50% goes to cities, which would prevent it from going to one project. However, and I understand exactly your point. I think we should be cautious splitting it up in that way, though, because some counties do have a greater need than others. It could be that there are more roads and bridges that need repair in Congressional District 2 than in Congressional District 3. And we don't want to not use all the funds for the 3-year period, and we don't want to limit getting important emergency road and bridge repair done. I think that using the emergency road and bridge repair fund would suffice, because it uses a board essentially to divert these monies.
Mr. Chairman, thank you for your consideration. I'm going to stay with my amendment and ask that only 25% of the funds of this fund be spent in any one of the 4 congressional districts. That's my amendment. That would include funds being spent in the county or the cities of any 4 congressional districts. I want to be sure that the money spread equitably across the entire state.
Okay, and are these on the amendment?
Yes, sir.
Okay, Senator Sojourner?
I have a question, Mr. Chairman.
Just one second, Senator Jordan.
Okay, excuse me.
Thank you, Mr. Chairman. To Senator McMahon's point, I would like to say that as far as the disbursements and the way they are handled through the ERB and the formula that they have established, that Chad's language would be in direct contradiction to that, and we pulled that language forward. I would also just like to say that I worked extensively with both MML, the Supervisors Association, and numerous other organizations who are a part of ERB to craft this language. It is very specifically crafted so that they feel like using their formula system, they can address the most critical needs expeditiously as possible. I do know that those organizations would not support such an amendment because they believe that the language in place is sufficient to help them adequately disperse it across the state to the most critical needs in a prioritized fashion.
Thank you. Senator Jordan, on the amendment?
Yes, thank you, Mr. Chairman. I just want to speak to on the amendment. 25% to each of the 4 congressional districts, be absolutely sure that each district receives some of that revenue. And then if districts need more, then that would be up to them. But I think it would be unfair for some districts to get all of it, 60% of it. In that way, we would be absolutely sure, and since we have the major road problem, that each district would benefit from it. I'm speaking of the amendment that is being offered, which I think is a good amendment. Be absolutely sure that it is spreading. Thank you.
Thank you, Senator Jordan. Senator Barnett?
Thank you, Mr. Chairman. I want to speak on the amendment as well, and I support Senator McMahon on the amendment because I think it's only fair that we make sure that those individuals in the congressional districts are receiving the fair amount of funds. And I think Senator McMahon is speaking on this from his time as being as a alderman there, and my time as being the mayor. I have seen it over the years as to where smaller municipalities and smaller counties are sometimes left out of something that's supposed to be meant for something equally. And let me give you all one demonstration when we talk about that. Jasper County, Mississippi, at one time, and maybe now, is the first or second most in oil production in the state of Mississippi. 18-point-something million dollars is collected annually from Jasper County that goes to the state of Mississippi for oil and gas severance money. But when we're talking about the amount of monies coming back from the state to Jasper County, it's probably less than 1%. So when we talk about being, you know, the money is going to where it's intended to be based on fairness, I think that Senator McMahon raises a valid point, and 25% equally distributed across those districts is a way to make sure that everyone has their fair share. Thank you.
Thank you, Senator Barnett. Senator McDaniel?
This money is being reallocated to a different source, or different, what's the name of that again?
The Emergency Road and Bridge Repair Fund?
Emergency Road and Bridges. What's the current criteria by which it administers its present funds?
So it's section 65-1-179. Just one second. It's based on the advice of the board, the advisory board.
Okay, and they have some discretion in how they move that money?
Yes.
Now, here's my question. Senator McMahon's amendment seems to apply to this money we're reallocating.
Yes.
Then, by definition, it would not apply to all the other monies that are presently being held.
That's correct. It would just apply to this
Just
$80
to
million.
this $80 million?
That's correct, yes.
Okay. So you're going to put someone in a strange position of setting aside a money that's already been set aside with different conditions for application and administering.
It would be, this bill repurposes the fund for the 3 years.
The entire fund?
Yes.
The entire fund, not just the 80 million? Okay. Because this amendment would impact the entire fund?
Yes. 86 to 97 of the lines.
And naturally, the supervisors have indicated that they would not be for an amendment of this nature. They don't want this bill amended. Here's my question. 4 congressional districts, right?
Yes.
And each congressional district has its own unique makeup of highways, streets, and roads.
That's correct.
Some have more highway, streets, and roads than others, correct?
Yes.
If we force an equal distribution, aren't we neglecting the districts that may need it the most?
That could potentially happen.
Potentially, these districts could see problems, could ask for money to fix those problems, but because of some forced allocation, the people in the best position to make that determination can't even make that determination. They'd be bound by statute, would they not?
They could be limited on the amount of funds they send to a particular district.
Right, forcing that district to suffer at the expense of the others. Okay, thank you.
Senator Blunt?
Thank you, Mr. Chairman. I appreciate what Senator McMahon's trying to do, and I think all of us sometimes feel like our areas of the state aren't getting our fair share, and I know that, but I can't support the amendment because, as I understand it, it requires every congressional district to get 25% of the money. So $80 million a year from the lottery, everybody gets $20 million. So if District 1 gets $20 million, and District 2 gets $20 million, and District 3 gets $21 million, and District 4 gets $19 million, nobody gets any money. I mean, you literally, mathematically, can't do it. You have $80 million, you have $20 million for each of the 4 congressional districts, and if somebody gets $19,900,000, they didn't get 25%, well, you can't do it. So, I mean, I just don't know. I think it's well-intentioned, but I just don't think it works, and I think we've got a plan, and it's been brought together, and so I should vote no on the amendment.
Senator Barnett?
Okay.
He passed.
Sorry, Senator Blackburn.
Under the existing roads and bridges program, do they not do it based upon need in terms of, I thought they come, the counties and the state aid engineer go together and inspect all the bridges, and then isn't it prioritized on need?
Let me know if I'm not answering your question the way you're asking it, but the way I understand it, there's multiple funds. One that we set up back in 2018, split money between counties and cities. I think the county money went out along the state aid road project dollars, I believe. The cities were broken down by a third, maybe an equal share. I don't remember all the details, but there was a formula for both of them to get monies. And that formula is still intact for use tax. This is different. It was set up specifically for the Emergency Road and Bridge Repair Fund Advisory Board to review projects that were emergency needs and disperse the money from there, or direct the disbursement of the money by MDOT.
And so they do have a criteria for dispersing the monies, I assume.
I believe so, yes.
Not politics.
We didn't codify a specific formula, but it is intended that it be for emergency use. So, for instance, like I gave you an example earlier, in a county where a wood piling bridge is deemed unsafe and is closed, the county may or may not have the funds available to fix that. People are having to drive a long ways to get around. This would help fund replacing that bridge.
Okay, and the 80 million that's presently going, how is that dispersed?
It's dispersed through MDOT for state highway projects.
Okay, thank you.
Anything else on the amendment? Senator Sojourner?
Yes, just real quick, Mr. Chairman. I appreciate Senator Blunt's comments, and I also understand the intent of Senator McMahon's amendment. But at the same time, the system is in place and is approved by the supervisors, MML, and all the other trade organizations who sit on the board to be able to formulate the money or to disperse the money to the needs that are in most critical needs. I'd also just like to point out that if anyone would like to look, I've got a state map that shows where the funds from last year for the ERB fund were distributed. And if you look across the state, I mean, you can't find more equal distribution across the state. But at the same time, it gives them the flexibility to prioritize in those most critically needed areas.
Thank you. Senator Parker?
I'll just make the comment to Senator Blunt's inability of the state to come up with 25%. I do believe if I had $100 in my pocket, I could divide that up equally amongst 4 people and have everybody be happy with that. I do realize that certain projects might have a price tag of maybe $8,000, and when you get to the end of that allocation, you might say, well, I can't get to an exact 25% distribution, but I think that one could be, be partially funded for the year, or I don't really understand the reasoning of not being able to equally divide it. And also, to Senator Sojourner's point, if I understand what she's saying, if indeed the projects are already being, funded across the state, and there are all these projects that are necessary everywhere, I don't really see any disadvantage to dividing it and prioritizing it by each district if we have that need everywhere. I just too many times in our situation to the north part of the state, as somebody has to drive quite a ways to get here, and I will be speaking about this with food distribution later in public health. I see time after time after time where resources, unfortunately, have a more difficult time reaching the end user than they do from the originating source. And I have just seen in many instances where And I don't think that there's intent in that. I'm not suggesting that there's any situation where someone says, well, we're going to, punish this area in the state. But it is much more difficult for the supervisors from DeSoto County and from counties that are extreme edges of the state to get here to Jackson and maybe have the important meetings to express their concerns and to do that. And I have seen the map data that you've seen there, and I do agree that we have needs everywhere. But I agree with Senator McMahon that if we have that in there, at least for this small part for 3 years, we would be saying, okay, we have tried our best to make this equitable and fair because we're changing this because the need is great at this time. So,
Mr. Chairman, may I speak?
Yes.
To the amendment?
Yes, sir.
I thank everyone for their thoughts and comments. Look, all of Mississippi is important to me. It's one state, one fate. What's happening on the coast is just as important to me as what's happening in the Delta or what's happening in the central Mississippi or in northeast Mississippi. I want to be sure that everyone understands the amendment. There's money being allocated every year to roads and bridges. $80 million from the lottery fund goes to education. And then let's say that there's $40 million left this year for the sake of dividing it equally. An additional $40 million is going to go to the road and bridge repair fund. And if that $40 million goes, it has to, that $40 million that's from the lottery has to be divided and spent equitably and equally across all 4 congressional districts. That is the intent of this amendment. And I stand by the amendment and ask you to vote for it.
Yes.
Apologize for signaling from behind. I've asked the amendment, and I think Senator McMahon understands what he's saying, except the first 80 goes to roads and bridges, not the other way around.
Right.
Okay, so there's a guaranteed 80, and it's also my understanding that there is no match requirement, that was stricken as it relates to this 80. I do want to make sure I understand that, because if there is no match requirement, you take 80 and divide it by 4, you got 20. You divide 20 by 2 because you got county municipalities. That's $10 million per congressional district for counties and 10 for cities, and you give it in a block grant format. This is not that hard. I have a project in Tishomingo County. It's a $1.5 million project. I can apply for grants to this. I might get $500,000. But it's $10 million to each of the counties and cities in each congressional district. If I misunderstand it, correct me, but I don't see the match language. Match language was struck. So this is $80 million, could easily be set aside and appropriated as the amendment is stated, and I support the amendment.
Okay.
Thank you. I stand corrected.
We're nearly out of time. We're going to need to wrap up this meeting. One more question on the amendment, then we're going to take up the amendment. We're going to vote on the bill.
I just want to say that if we're trying to split this up evenly according to the fair way to do it, look and see where all the lottery money's coming from and split it up that way if you want to do it that way. If not, be for Mississippi and let it be split up where it needs to go.
Fair enough. All right, motion is for adoption of the amendment. All those in favor, say aye.
Aye.
Any opposed?
No.
Ayes have it. On the bill, motion is title sufficient, do pass committee sub. All those in favor?
Aye.
Aye. Opposed? All right, bill passes. We have one more to take up. Senate Bill 2831, we laid this on the table yesterday, subject to call. We had feedback from Senator Bryan, Senator McMahon, and Senator Younger about some potential changes. We have some, to try to accommodate those changes, which all seem to be good suggestions. If you'll look at line 98, we'd like to propose an amendment to change the first word "the" to "a," and then after tax credit, insert "for which the department issued a certificate of eligible credit on or after July 1st, 2021. This is to accommodate Senator Bryan's concerns of people who currently hold credits being able to benefit under a new system that they did not originally apply for. And on line 169, after fiscal year, we'd like to amend to add, no one taxpayer may be awarded a credit in excess of $3 million in any one state fiscal year. This would prevent any one entity or taxpayer from claiming the entire $12 million credit, allowing at least 4 people to receive the credit. Does anybody have any questions on those amendments?
Question.
Senator Horn?
So if I'm understanding the latter part of your amendment, nobody can get more than 3 million in credits in any one program year. Is that correct?
That's correct.
Okay, but I understand the interest of folks who have smaller projects, who are concerned about those guys with larger projects, coming in and consuming most of the credits. But there are large projects out there that require or could use credits in excess of $3 million. Why don't we look at, or has there been any discussion about looking at any projects that are less than $3 million not being subject to the cap?
So there's been lots of suggestions on creating possibly a queue that you can get into after you pass phase 2 of the historic tax credit, so that once you get to phase 3, you're approved. There's been suggestions to raise the cap. We can definitely look into any of those, but we were not prepared to make those changes right now since yesterday's meeting. Happy to look at those with you and look at ways we can improve this bill as we go forward.
Well, thank you, Mr. Chairman. Once we get beyond the amendments you're proposing, I'd like to ask for a reverse repealer.
Okay. Any other questions on the amendment? Motion is to adopt the amendment. All those in favor say aye. Aye. Any opposed?
No.
All right. Amendment is in. On the bill, there's an...
I'd like to move that we put a reverse repealer in the bill.
All those in favor say aye.
Aye.
Any opposed? All right. Any questions on the bill?
Todd Fisher, do pass committee sub.
Motion is Todd sufficient, do pass committee sub. All those in favor say aye.
Aye.
Any opposed? Thank you. Right. Motion, right of report.